thank you all for coming. I'm going to open us up this morning with a discussion. This faculty panel is going to talk about issues of race in their own scholarship. And I'm going to encourage us in the Q&A to explore issues of race in advocacy within the legal profession more generally, in our classrooms. How do we talk about race in the teaching that we do? So your experience as students in those classes will be particularly relevant. I hope that you'll join us in the Q&A for this important discussion. We're going to begin with Professor Shaughnessy, followed by Professor Jon Shapiro, followed by Professor Spencer. Now, these are people who I am sure need absolutely no introduction to you all. So I'm going to skip long formal introductions and allow them to get into their presentations. Professor Shaughnessy.
Thank you, Joanna. I apologize in advance. I have a little touch of flu, so I hope my voice isn't too impacted. What I wanted to do is tell you the stories of 3 fabulous cases, all too briefly, all of which implicate the role of the federal courts, the federal judiciary, in dealing with issues of race. The first case is fairly called notorious, maybe the most notorious case ever. It is the case of Dred Scott versus Sanford. Here is Dred Scott, who was born a slave in Virginia sometime around 1800. Dred Scott moved west, and by 1830 he was in St. Louis, Missouri. St. Louis by then had been admitted, Missouri by then had been admitted to the United States as a slave state pursuant to the Missouri Compromise. The Missouri Compromise was an attempt to settle the very contentious issue of whether or not there would be slavery in the territories that the United States was acquiring in its great westward expansions. And the deal was that north of a certain line, the territories would be free and would enter the Union as free states. South of a certain line, they would enter as slave states. So, Dred Scott in 1833 is sold to an army surgeon by the name of Emerson. Emerson is then stationed first in Illinois, a free state, at Fort Armstrong, and thereafter in the Wisconsin Territory, in what is now known as Minnesota, at Fort Snelling. This is Fort Snelling right here. Okay. Ultimately, Emerson dies. Scott and his family pass to Emerson's widow, and Scott and his family live and are rented out as slaves in St. Louis, really under the supervision of the widow's New York brother, Sanford, who had business connections in St. Louis. It bears noting that had they known to do so, the Sanfords could probably have obtained their freedom through litigation either in Illinois or in the Missouri Territory, or even in Missouri when they returned there, because Missouri law for a long time reflected an understanding of slavery consistent with the great case of Somerset versus Stewart from the King's Bench, which said that when a slave is taken into a free territory, their slave status ends. And Missouri, through most of the early 1800s, in case after case, had held to that. But the Scots did not litigate for a time until after Emerson died. The Scots then sued in Missouri State Court for their freedom, and consistent with the Missouri precedents I've told you about, won a declaration of freedom in Missouri State Court. But that declaration was appealed, and the Missouri Supreme Court said in a fairly directly political opinion that the issue of slavery had changed, and this was no time for any softening on the issue of slavery to be seen on the part of any slave state, and therefore the Missouri Supreme Court held Missouri would no longer recognize a stay in a free jurisdiction as the grounds for ending a slave status. So that was the end of the state court litigation. 1854, Scott brings a diversity action in federal court against Sanford, the brother of his owner, claiming battery and false imprisonment. The lower court follows the earlier Missouri case and finds that on the grounds of the Missouri opinion, the Scots were still slaves. The case went to the Supreme Court. The Supreme Court could have simply affirmed on the grounds of the lower court, but they chose to go very substantially further. They chose first to inquire into the question of whether any black person, regardless of their slave or free status, could possibly be a citizen of the United States for purposes of the diversity jurisdiction. And the court, in an opinion by Roger Bertani, answered no. In what might be the most notorious language ever published in the U.S. reports, blacks are so far inferior that they have no rights white men are bound to respect, said the court. So I think we could all agree that that was pretty much bad enough. But the Supreme Court in Dred Scott goes on to take on another question which should have been A, unnecessary, given that they'd already decided the case lacked jurisdiction, and B, improper, given that they'd already decided that they lacked jurisdiction. Nevertheless, the court thought they had a hook to address the question of Congress's power over slavery in the territories going forward. And the Supreme Court in Dred Scott goes on to find that Congress lacked the power, and had always lacked the power, to exclude slavery from the territories, and thus that the Missouri Compromise and similar legislation was an unconstitutional violation of the Fifth Amendment, thus paving the way, with many other things, for the Civil War itself. I think probably many of you are aware that the lead up to Lincoln's first election was a debate about Dred Scott itself and about its scope and meaning, and in particular about whether Congress was required to abide by what the new Republicans regarded as bare dicta and shocking and impermissible dicta at that. Lincoln very much took the view that the parties to Dred Scott were bound by the decision, but that the political branches were not bound to concede that they lacked the power to deal with slavery in the territories. So that is story number one of the Supreme Court reaching out in a failed attempt to dictate a solution to a huge racial problem. And what I think most of us now accept was an overreaching moral mistake and a blot on the court. Okay, so we'll move this thing forward quickly. We will move past the Civil War and Reconstruction and Jim Crow, and we will notice that the aftermath of slavery and the Civil War lingers for a long time. It lingers in the South in the form of Jim Crow, and it lingers in the North as well. One thing that happened during and after the First World War is that blacks moved in great numbers from the rural South to the industrial North. They were pulled by industrial jobs. They were pushed by the horrible conditions in the rural South. Chicago was the recipient of many members of what's come to be called the Great Migration. And being a Chicagoan myself, going back a few generations, I'm ashamed to say that they did not handle it well. Chicago responded with violent race riots in the late 1910s, and they also responded at the highest levels of business with an organized campaign by powerful institutions. Good evidence that perhaps my law school alma mater might have had a little bit of a role in this, I'm also ashamed to say, University of Chicago, to squeeze arriving Southern blacks into small sections of the city. They did this through racially restrictive residential covenants, voluntary racially restrictive covenants. The idea was that you would go around a whole neighborhood and get virtually everyone to sign on, at which point the covenant would be legally enforceable. The Supreme Court egged this on a bit in a case called Corrigan versus Buckley, when they summarily dismissed a challenge to private racially restrictive covenants on 14th Amendment grounds. This was reasonably effective. The black areas of Chicago were very overcrowded. The real estate was very highly priced, and the city was successfully racially segregated, and I should say remains pretty racially segregated as we speak along these lines that were instituted post-World War I. There was a certain neighborhood called the Washington Park Subdivision. I hope that's my next slide. No, that's not my next slide. Here it is. Washington Park Subdivision, where such a covenant was attempted. It's not at all clear that they ever got all the signatures they needed, but either they thought they had them or decided to pull the wool over a court's eyes in order to persuade it that they had them, in order to get a court validation of the enforceability of the racially restrictive covenant on the Washington Park subdivision. So a litigation called Burke versus Kleinman was brought along these lines. And the Illinois state courts found that the racially restrictive covenant was in force and enforceable. Burke versus Kleinman was brought as sort of a class action lawsuit. In 1937, the Hansberry family, excuse the blurriness, bought a house called a 3-flat in Chicago parlance at 6140 South Rhodes in the Washington Park subdivision. I should say that, of course, we're in the Depression, and in white neighborhoods in Chicago, economic distress has started to put some pressure on these racially restrictive covenants, because sometimes there were no buyers other than black buyers for these homes people were anxious to sell, and that may partly explain this sale. The Hansberrys and their seller were sued in a case called Lee versus Hansberry in order to enforce the racially restrictive covenant and evict the Hansberrys from their home. The trial court held for the Hansberrys, and ultimately the case worked its way up to the Supreme Court, reaching the court in 1940. The court could have done a lot of things. They could have tackled the substantive question of whether racially restrictive covenant enforcement is state action for purposes of the 14th Amendment. Ultimately, they do that after the Second World War, but they weren't quite there yet. So if you read Hansberry versus Lee, it doesn't read much like equal protection case. It reads like a procedural due process case. It's one of the great procedural due process cases about what it takes to bind someone who's allegedly represented in an earlier lawsuit, class action, and forbid them from litigating on their own. So Hansberry versus Lee comes out in favor of Hansberry, the defendant, on the grounds that Hansberry should not have been forbidden from challenging the racially restrictive covenant anew on the merits, because Hansberry was not properly bound by the earlier lawsuit. But in some ways, the court was ducking. They were using procedural due process as a way to find for the Hansberrys without getting to the guts and the core of this issue, that is the constitutionality of what was being done to black homebuyers in Chicago and many other parts of the country. So that's story number 2, and I should show you, you probably know this story because it is the story of Lorraine Hansberry's family. Lorraine Hansberry was the daughter of the litigant in Hansberry versus Lee, and her great play, A Raisin in the Sun, is the story of that experience from the inside. Last story that was also talked about yesterday that I don't want to talk about for too long because I'm already running out of time, takes us forward a couple of decades. It takes us to the immediate aftermath of Brown versus Board of Education. Specifically, it takes us to Little Rock, Arkansas, where for a time it looked as though the implementation of Brown was going to go nicely in Little Rock. The school board put something in place even before the Supreme Court handed down its second Brown decision about remedy. They were willing to go forward. Little Rock had been considered a relatively, as these things go in the South, a relatively moderate place in terms of race relations. But the governor, Orville Faubus, who himself seems for a time to have been a relatively non-racist guy, saw political advantage in taking a different tact. So he and the legislature really revved up the opposition to Brown and to school integration. And when the first students arrived to integrate the white high school in Little Rock, Arkansas, Governor Faubus was there. I hope Governor Faubus is here. Governor Faubus was there, and so was the Arkansas National Guard, barring the students' entry to the high school. This went on for a few weeks until the federal court overseeing the desegregation litigation ordered Faubus and the National Guard out of there, and he left. In the aftermath of the departure of the Arkansas National Guard and Faubus, there were riots. The students attempted to attend school and were unable to stay because of the out-of-control mob. And ultimately, President Eisenhower was forced to send in paratroopers. This is not a very good picture. I apologize again. But these are the students being led in by the U.S. military. Eisenhower then nationalized the Arkansas Guard, and they stayed all year long. And the students had a pretty hellish year being the leaders of desegregation at their school. The case gets to the Supreme Court as Cooper versus Aaron, and the question essentially in Cooper versus Aaron has to do with remedy and the scope of the district court's ability to use its injunctive power against parties beyond the original named parties. The Supreme Court holds that desegregation should not be delayed and requires the district court to go forward with the original plan. But in the course of this, the Supreme Court speaks to the requirement of state politicians to obey the dictates of the Supreme Court's decisions, and essentially goes full circle from Dred Scott. That is, the court said that the premise of the action of the governor and legislature is that they are not bound by our holding in the Brown case. The court said that's wrong. Marbury versus Madison declared that the federal judiciary is supreme in the exposition of the Constitution, and went on to say, it follows that the interpretations of the 14th Amendment enunciated by this court in the Brown case is the Supreme Court of the land, and that state legislatures and executives and judicial officers cannot war on the Constitution without violating their oath to support it and the court's decisions under it. So Cooper versus Aaron really addresses the very same question that Lincoln took up in the aftermath of Dred Scott, and takes a very different view of what I think is still a debatable question of constitutional law. So thank you all very much.
Thank you very much, Professor Shaughnessy. I'm going to retract what I said earlier and exercise my moderator's prerogative for a moment and introduce Professor Shapiro, because although I'm confident that you all know Professor Shaughnessy and that you know Professor Spencer, I'm not sure that you've had the privilege of having Professor Shapiro in class. So with that, let me just say a few words about Professor Jon Shapiro. Professor Shapiro has practiced criminal defense law for 39 years in the D.C. area and has represented some of the defendants that I'm sure you all have heard of. He represented, for example, the D.C. sniper, John Muhammad, among many others, and is considered a preeminent criminal defense lawyer and one of the most successful and sought-after criminal defense lawyers in the country. So the fact that we have convinced him to come teach with us is quite a coup. So I just wanted you all to have that background information, and with that, I'll turn it over to Professor Shapiro.
Thanks, Joanna. Lies and damn lies, as they say. I want to talk a little bit about the death penalty in this country. I have to start out with something I always think about on Martin Luther King's birthday, the March on Washington. When I was 14 or 15 years old and had planned to go, I was so looking forward to it. I was going to take the bus from Cranford, New Jersey, and meet my aunt in Washington. She was a notorious radical. Her name was Mike, if that's any clue. And I got so sick, and I had to watch from my bed throwing up, but it left a lasting impression on me. In any event, think about this conversation. You're in a jail cell. You're talking to your client who's charged with murder, and the state is seeking a sentence of death. Your client is black. He's charged with killing a white man in a robbery, and he wants to know how things look. Justice Brennan imagined just such a conversation in his dissent in a case called McCleskey versus Kemp in 1987. That's just 25 years ago, which to me isn't a hell of a long time ago. To you, it may seem like an eternity. And here's how Justice Brennan figured the conversation would go. This is Justice Brennan's language. First, counsel would have to tell Ms. McCleskey that few of the details of the crime or of McCleskey's past criminal conduct were more important than the fact that his victim was white. Furthermore, counsel would feel bound to tell McCleskey that defendants charged with killing white victims in Georgia are 4.3 times as likely to be sentenced to death as defendants charged with killing blacks. The story could be told in a variety of ways, but McCleskey could not fail to grasp its essence, its essential narrative line. There was a significant chance that race would play a prominent role in determining whether he lived or died. Now, McCleskey was an unfortunate Supreme Court opinion. McCleskey, of course, was seeking relief from a sentence of death. The court in McCleskey did not even question the statistics that Justice Brennan recited. Nevertheless, it rejected McCleskey's claim that those facts made his sentence of death unconstitutional. Now, McCleskey had presented the court with a comprehensive study of how the death penalty played out in Georgia. It was called the Baldus Study by Professor Baldus and others, a sophisticated statistical analysis employing regression analysis and all kinds of other fancy things that are meaningless to me. It basically looked at 2,000 Georgia murder cases during the 1970s. Here were the findings, and if I could, here is sort of the summary of the Baldus study. It's broken down into two realms. When death was imposed as a result of a criminal trial, a death penalty trial, and when it was sought. And the findings were remarkable. You can see that when a black defendant was charged with killing a white victim, death was imposed in 22% of the cases. White defendants charged with killing white victims, 8%. White defendants killing black victims, 3%. Black defendants killing black victims, 1%. And where the decision was made by the prosecution to seek death, if you were a black defendant with a white victim, 70% of the cases, the prosecution sought capital punishment. White defendants, white victims, it dropped to 32%. White defendants, black victims, 19%. Black defendants, black victims, only 15%. A remarkable story in those statistics. McCleskey was authored by Justice Powell. And the guts of the opinion was to get relief, Mr. McCleskey would have to do more than show the history of racial bias in Georgia. He would have to show that it operated in his particular case, something that scholars and an editorial in the New York Times at the time called an intolerably heavy burden of proof. And 7 years later, now off the court, as a matter of fact, Justice Powell, I think that this was his last year on the court when he authored McCleskey, had a change of heart. He said he regretted the decision in McCleskey, but of course it was too late for Mr. McCleskey and for many others who had gone to their deaths as a result of that. The Baldus study threw a spotlight on what was already painfully clear to many, that the death penalty and how it's applied in this country is an anachronism from a time of flagrant injustice. Indeed, it's instructive to look at the briefs filed in the Furman case where the Supreme Court ruled the death penalty as applied unconstitutional. That was in 1972. In its brief in that case, the NAACP took great pains to outline the history of racially motivated use of the death penalty in this country with its roots in lynchings and vigilantism. The NAACP in that brief pointed out the American slave codes. These were sets of punishments in effect, which treated slaves much differently than whites who had committed similar crimes. Did you know that authorized punishments for slaves who ran afoul of some of those laws were crucifixion, burning, and starvation? The NAACP wrote in its brief, "The total history of the administration of capital punishment in America, both through formal authority and informally, is persuasive evidence that racial discrimination was, and still is, an impermissible factor in the disproportionate imposition of the death penalty upon non-white American citizens." And the brief presented these stark facts. From 1882 to 1903, that's just 21 years, 1,985 blacks were killed by Southern lynch mobs. From 1903 to 1935, that's just 32 years, 1,015 blacks were lynched. And that doesn't include people who died in race riots or the result of kangaroo court justice. And they noted that of the 3,334 persons executed between 1930 and 1968, I guess some people would call that the modern age, almost half were black. Now, likely no one here doesn't already know or have the sense that race remains a big factor in our criminal justice system, from start to finish. It affects who gets arrested versus who gets warned. It affects who gets held in jail, who gets bail, who gets prosecuted, who gets deferred, who gets to stay on a jury, who gets kicked off a jury. It affects what the sentence is ultimately. Race is lurking around the edges, if not front and center, in all of these issues. Death penalty aside, Exhibit A, the battle over crack sentencing, which most of you are probably familiar with, and the racial underpinnings of the laws controlling crack versus cocaine, and the punishments involved in that. I don't need to go through the history of that, and I don't even have the time. Exhibit B, the issue of the use of preemptory strikes and jury selection. We have Batson versus Kentucky, which helps deal with that, largely an ineffective case. And anybody who sits in a courtroom in the United States and sees how preemptories are used today will understand quickly that based on the color of your skin, that alone may determine whether you sit on a jury or you don't sit on a jury. Whether that's used consciously or unconsciously by the prosecution or the defense. But by far, the place where the disgrace of discrimination in the criminal law is most obvious is that area where the stakes are the most highest, or are the highest. And that is the wretched and shameful corner of criminal law called the death penalty. I have no problem characterizing it that way. I've seen my share of executions. The Supreme Court rejected McCleskey's claims. They shunted aside Professor Baldus, but you just can't hide the truth. The evidence of racial discrimination is right in the death rows and execution chambers. It's not a secret. It's not a subtle point. Did Baldus get it right in his study? Well, surely things must have changed since McCleskey was decided, but no, they haven't. 3 years later, in 1990, the GAO, in a study of the death penalty, said in 82% of studies, race of the victim was found to influence the likelihood of being charged with capital murder or receiving the death penalty. That is, those who murdered whites were found more likely to be sentenced to death than those who murdered blacks. And it's not just a little more likely. Next chart is executions for interracial murders. Take a look at this. Since 1976, it's a stark disparity. When you have a white defendant killing a black victim, you can see what the rate is versus a black defendant killing a white victim. So in total, white defendant, black victim, 19 executions. Black defendant, white victim, 257. That's since 1967. Here are some other shocking figures. This is executions by race since 1608, from a great study which you can find on the Death Penalty Information Center website. You take a look at this. We're just getting to the bottom line. 15,700 executions since 1608 in this country through 2011. 47% have been black defendants. Read executions in Virginia by race. Just in our state, 1608 to 2002, I'm sorry I don't have the most recent statistics, 1,169 blacks have been executed, 218 whites, 84% versus 15%. Death row inmates, this is also a little outdated. On death row now, as of 2000, federally, which has a much smaller population of people set for execution. There are 19 as of 2000. 4 whites, 13 blacks, 1 Hispanic, 1 other. Blacks comprising 68% of that population. And just some more blood-chilling kind of history for whatever it's worth. Juveniles executed in Virginia going back to 1787. 13 juveniles. I don't see a white face listed. All black. Starting with the youngest at 12 years of age. And that is a case in which I believe that this young child did not weigh enough to be killed by the hangman's noose, and people had to pull on his body in order to break his neck or asphyxiate him. 12, 13, 16, 17, 16, 16, and 17. Thank goodness our enlightened society at this point will not execute someone who committed their crime when they were younger than 18. And finally, females executed in Virginia, 1608 to present. Now take a look at this. 73 black women and children against 12 whites, 85%. I mean, the numbers tell the story. I mean, they were dealing and have dealt for years and still dealing with the issue of race in the administration of criminal justice. It's conscious and subconscious. I walked into a courtroom last year to see part of a death penalty case, and there were 3 folks sitting at the defense table and 3 at the prosecution table. I looked at the defense table and I thought, well, there's 3 lawyers. But in fact, one of them was the defendant. He turned out to be white. His name was Lawler. And he was dressed up in a suit. And it made me reflect back on the death penalty case that I had recently tried, where my client was Hispanic and covered with tattoos. And the difference was stark. Now, you could see almost that the jurors had at least a basis for relating to this person on some level, Lawler, whereas they didn't in Prieto. Unfortunately, they both received the death penalty. Anyway, things are looking up, believe it or not, and the death penalty is getting a pretty good kicking these days. Maryland is set to get rid of it. If you've been reading the newspapers, you know what's going on there. New Jersey let it go in 2007. New Mexico in 2009. Connecticut, 2012. New York, 2007. Illinois, 2011. This has been caused by a combination of things. Conscience, for one, I believe, but also embarrassment over exonerations. Did you know that of the how many exonerations from death row now based on DNA? Over 100. In 30 of those cases, the defendants had confessed and they were demonstrably innocent. People are starting to worry about that. The other thing at play here is money, I think. In these harsh financial times, it just costs too much money to go through the whole death penalty process. And so I think that is part of what I hope is the death knell of this process. And there is great work going on across the country. We have two heroes right here in our law school. One of them sitting right there, David Bruck and Judy Clark, who are doing phenomenal work to put an end to this disgrace. Yes?
She's over here.
I'm Judy. Oh. Both of whom look like they've sobered up from my party last night. Anyway, as David is fond of quoting Dylan Thomas, the day will come when death shall have no dominion. Thank you.
Thank you very much, Professor Shapiro. Now I turn it over to Professor Spencer.
Okay, so I'm here to talk about civil procedure, so try to stay awake. It's not, to some, at first blush, as interesting as criminal law, but as my students know, and I always point out to them, that procedure is very important. That's one of the things I'm going to try to discuss today. And I won't do it in terms, strictly speaking, of race, but it's more so going to be about access to justice. And the main thing to understand is that substantive law is very important, but substantive law is meaningless without the procedure to enforce it. It's very critical for people to understand that. I emphasize that to my students all the time. We have limited resources in the United States. The government can't personally enforce every violation, so we rely on private litigants to enforce the law. And to the extent that the procedure that we have in the judicial system facilitates access and allows plaintiffs access to court to enforce the law, you're going to have a greater vindication of the substantive policies that substantive law is reflecting. Conversely, to the extent that procedure is more restrictive and constraining, access restricting, you're going to have less enforcement of the substantive policy behind the substantive law. So the role of procedure it's not something that you should think of as just on the side or something as secondary or as an afterthought. But it's really vitally important. If you care about civil rights law, if you care about employment discrimination, you have to care about the procedure to enforce it. And far too often, we focus entirely on the substantive law. So you have marches on Washington to have the Civil Rights Act. You're never going to have a march on Washington for a rule of federal civil procedure or for part of Title 28, and nor should you. But everyone focuses on, let's have the Voting Rights Act, let's have the Civil Rights Act, let's have all of these things that provide substantive rights. No one focuses on whether these can ever be enforced. And part of the reason is that these things have been delegated mostly away from Congress into the hands of rulemakers, in the hands of the courts, groups that people don't pay a lot of attention to. And as we had a lot more public law legislation in the 60s, like the Civil Rights Act that came into force, in combination with a revolutionary overhaul of Rule 23, which is the class action rule, you had a lot of empowerment of litigants who were able to get into court and start vindicating these rights through class actions and bringing these lawsuits under new statutes that were created in the 60s. And suddenly you had a very open procedural system that was given to us in 1938 that was facilitating claims by outgroups, if you will, by minorities, by victims of discrimination coming into the courts. And so I've told this story to my students in my seminar class that in the 1970s there was a reaction to this, that litigation by these groups was seen as something that was not desired. So Chief Justice Burke led an effort to reform procedure in a way that started restricting access to the courts. and that was done in a series of amendments to the rules. Rule 16, which gave judges more authority to eliminate what they saw as frivolous claims. Rule 11 was made more strict, and it turns out that it deterred a lot of civil rights plaintiffs from bringing their cases forward. In 1986, the summary judgment rules was strengthened to give defendants a much stronger hand in having cases of plaintiffs dismissed before they could get to a trial. And we still have a lot of these things going on today, and I'll talk just briefly about a few specific areas in civil procedure of late, and late is now the past 30 to 40 years, that have moved procedure in a restrictive direction that tends to discourage access to justice. One thing that we've seen recently is in the area of personal jurisdiction, when you have out-of-state corporations who are able to sell products within a particular state that cause harm. The Supreme Court recently made it more difficult for victims of those accidents to bring suit against those manufacturers in the state where they belong and where they were harmed, and that is the Nicastro case out of New Jersey. Someone lost, I think, 3 or 4 fingers to this shearing machine that was sold by this foreign company, and the Supreme Court said, well, they used an intermediary out of Ohio that then shipped it into New Jersey, so this New Jersey victim can't sue in New Jersey because this out-of-state company doesn't have minimum contacts. Those of you who have taken civil procedure know what that means with New Jersey. Well, that means that victims in New Jersey are not going to have access to justice, even though they didn't ask for this to happen to them. They didn't bring the machine into New Jersey. But that was one access-restricting decision on the personal jurisdiction front. Everyone is probably more familiar with pleading decisions, those of you especially who have taken my class, where throughout the 80s, it actually started in the 60s, but it really picked up steam in the 80s and the 90s, courts were identifying certain types of claims, civil rights claims, employment discrimination claims, antitrust claims, and they were singling them out for heightened pleading requirements. So the Federal Rules of Civil Procedure say that you only have to provide a short and plain statement of the claim showing entitlement to relief. Well, certain courts took it upon themselves to say, well, that makes it too easy to assert certain types of claims. And in the 1950s, you had the case of Connolly versus Gibson, which was a discrimination case by members of a railroad workers union who were suing because they hadn't been represented to the same extent as white workers had been. And the response from the defendants were, well, you don't have enough information in this complaint. We need more facts. How do you know that we were discriminating based on race? And the Supreme Court said, they don't have to prove that at the outset. This is just pleading. All we require in the federal system is notice pleading. Do you have enough information there to know what they're talking about so we can move forward with the case? So that's Connolly versus Gibson. Well, in the 60s, 70s, and the 80s, the lower courts still were committed to this notion of heightened pleading, that you have to require more. It's too easy to say that there was discrimination. And on a couple of occasions, the Supreme Court said, you can't do that, lower courts, and these were unanimous decisions. So in 1992, the Leatherman decision, where the Supreme Court unanimously said, these judicially created heightened pleading standards, where are they coming from? Rule 8 doesn't require the pleading of facts. It's just notice pleading to get in. Stop doing this. The lower court said, well, we're going to limit it to the facts of that case. And that was a case seeking liability against a law enforcement agency. So the lower court still imposed heightened pleading, and then you get to 2002, the Supreme Court unanimously again says, what are you doing? You can't change notice pleading to heightened pleading through judicial reinterpretation. And this was an employment discrimination case. Again, discrimination, civil rights being the common theme there. You can't impose heightened pleading. Stop doing that. That was unanimous. Well, as my students know, in 2007 and then in 2009, the Supreme Court said, on second thought, we do like heightened pleading. We are going to start imposing fact pleading requirements, and you have to convince us that your claim is plausible. So in the 2009 case, again, this was an action by a Pakistani national against John Ashcroft and the head of the FBI, Bob Mueller, charging them with having authored and implemented a policy of discrimination, arresting people and holding them in harsh confinement conditions based on their national origin and their religion. And the Supreme Court didn't let it get past the pleading stage. There was a motion to dismiss. Again, Ashcroft and Mueller said, well, you don't have enough facts. How do you know that there was this policy? How do you know that this was discriminatory? And the Supreme Court said, that's right. These are conclusory allegations. We're going to set those to the side. What's left in your complaint, we don't really find it plausible that Ashcroft and Mueller would do this kind of thing. So the case is dismissed. So these are the pleading decisions that have restricted access to justice. You have something as mundane as you could think of as amendment is another area where you see some restriction on access to justice, and this is specifically in the area of relation back. Now, how technical and mundane can you get in the relation back of amendments under Rule 15? Well, if you have a case, and this case was Worthington versus Wilson, so you have someone who was roughed up by the police during his arrest. So it's a police brutality case. And the person, the victim, didn't know the identity of the police officers. So you sue them as John Does. So the statute of limitations period expires, which was a 2-year statute of limitations period. Through discovery, the plaintiff discovers the identity of these police officers. Now I know who they are. So instead of John Doe, I want to amend my complaint to name these specific police officers as defendants. Well, you can only do that under Rule 15C specifically if it's going to relate back to the time of filing. If you add these new people after the deadline, it's too late. You've missed the statute of limitations period. So you can't bring that claim. Well, the federal rules give you a remedy. 15C allows you to time travel and pretend that you named them before the statute of limitations period if you meet certain requirements. It has to be the same transaction and occurrence. There has to have been notice within 120 days of the pendency of this lawsuit. And one of the key elements that the court found was the reason that you failed to name those people initially had to have been due to a mistake. That's the language that you have in the rule. So what did the court say? The court said, that's not a mistake. Going from unknown to known, that doesn't count as a mistake. Going from wrong to right, that's a mistake. So if you had named the wrong people and wanted to fix it to the right people, you'd be good to go. But because you were naming unknown people, which is not your fault, and now you want to name known people, that's not going to work under 15C. So that case, he lost. So you can't proceed against the unknown police officers who are now known. Of course, the reason that they weren't known is because of non-cooperation from the police department. So that's the prevailing interpretation of 15C today, which I think is something that needs to change. But you can see there another instance of thwarting what would be a civil rights claim in my view. And the last thing I'll mention is the area of joinder and class actions. You have to have class actions, as I've explained to my students, to vindicate so-called negative value claims. If your claim is not worth enough to offset the litigation costs, then those claims are never going to be brought forward. Well, why do we care? Well, you can't have laws that make something illegal or make it unlawful to manufacture a dangerous product, for example, if everyone who's harmed by violation of that law is going to be harmed to the tune of $100 or $1,000, then the law is never going to be enforced. So you have to have joinder and class action rules to facilitate entry by these large groups of people who have suffered de minimis harm. So it's important to have these rules to get into the system. On the joinder side, that's when you have people actually joining together. I teach a case called Mosley versus General Motors, and these were 10 workers, African Americans, who were suing General Motors. They thought they were alleging that they were victims of a policy of discrimination. I can't recall if it was in promotion or if in compensation. And General Motors was saying that you can't join together. Now this is Rule 20. Again, it's a straightforward rule that allows multiple parties to join together if they have common questions of law or fact, and they are joined by the same transaction or occurrence. And General Motors is saying, no, you can't, you don't satisfy Rule 20. And I always ask the students, well, why would General Motors, wouldn't it be more efficient to just handle this all at once instead of trying to break this up? And what I get them to understand is that it's the battle between strength in numbers versus divide and conquer. Strength in numbers, when you have 10 people telling their stories to a jury, that's powerful. then they're going to say, well, something's going on here. They can't all be lying. But you break them up into individual groups. They each have to pay for their own lawyer. They each have more litigation expenses. Now they each go one-on-one against the jury. Maybe they'll win, maybe they won't. So that's just a Rule 20 case. And then lastly, Rule 23, which is the class action rule. We had a big decision in 2011 from the Supreme Court, which is the Walmart versus Dukes case. That was 1.5 million women suing Walmart for discrimination in promotion and compensation. And I encourage people to read this decision. It's pretty rough because the Supreme Court shuts them down. And they do this, it's Justice Scalia, and there's one simple requirement for it. Well, there's many requirements for class actions, and they're not all simple. But one of the ones that was supposed to be simple was that you have common questions of law or fact uniting the class. That's the commonality requirement. And Justice Scalia turned this into something that it doesn't even say on paper. And he's the one who says, read what it says and apply what it says, or apply, what it means historically. And he said, well, I read that to mean the common questions have to be important. They have to be central to the case. And here I don't see a central common issue that's uniting all of these women, which is complete nonsense. But it meant that they aren't able to proceed as a class. So you can just see from those examples, and there are others, that procedure really plays a very important role in giving litigants access to the courts. And if you don't have access to the courts, then you're not going to be able to vindicate the civil rights laws, employment discrimination laws, antitrust laws, these other things. And this is a continuing problem that's going on. We're moving in this direction. Not many folks are paying attention to it except proceduralists. And it's going to be a problem going forward because you're going to have all of these rights, but you're not going to really have a means of enforcing them. So I'll stop there. Hopefully people have a little more respect for civil procedure after this.